everybody in this room has a Judge Jenkins story or two. But these people have really a lot of Judge Jenkins stories. Let me introduce you to them. Judge Carolyn Mchugh, nearest to me, was a law clerk of Judge Jenkins in 1982 and 1983. She was a lawyer, ultimately a partner at the Parr Brown Law Firm from 1983 to 2005. She served on the as a judge on the Utah Court of Appeals from 2005 to 2014, and in 2014 she was nominated by President Obama to serve on the 10th Circuit Court of Appeals, confirmed by the Senate in March of 2014, so she's been on the bench in the Court of Appeals for about a year. Next is Ted Barnes, who served as Judge Jenkins's first clerk when he was a federal district court judge. Ted, after his clerkship, went to the Clyde Snow firm and is a partner there at present. Paul Simmons was a clerk for Judge Jenkins twice. Think about it. From 1985 to 1988, he served as Judge Jenkins' law clerk, and then he was persuaded to return in 1994, and he served from 1994 to 1996. Paul is a Dusnip King. He is an excellent and one of the premier appellate lawyers in our jurisdiction. And then finally, John Boyle. John Boyle was a law clerk for Judge Jenkins from 1996 to 1999, and since 1999 he has been counsel to the Skadden Arps firm in New York. So welcome all of you today. Ted, let me start with you. Tell us about the circumstances under which Judge Jenkins was appointed and became a federal district court judge, and tell us a little bit about your own clerkship.
Thank you, Alan. Some of this has been covered by Judge Thurman and others, but during the 77, 78 time period, there was some movement to create a third judgeship. One, because I think partly because of caseload, but partly because the then incumbent had no term limits because this was a two-judge district. Before that process worked its way through the Congress, Judge Ritter died, and that was in March of 1978. The third judgeship actually was approved a week after Judge Jenkins was sworn in, and Dave Winter was appointed to that position about a year later. But Judge Jenkins, as was indicated, was the referee in bankruptcy and then bankruptcy judge, was appointed by Jimmy Carter to fill Judge Ritter's seat, was confirmed by the Senate on September 20, according to the Wikipedia, that source. But by my personal knowledge, he was sworn in on October 11th. I was actually, Jim Beavers and I started the same day as law clerks. I claim sometimes primogeniture because I left first. But Jim and I started the same day on the 16th. Judge Jenkins would not commit to us. He led us along and said he'd like to hire us, but would not make any commitment on hiring until after he was sworn in on the 11th. He said too many things go on in the political process. We interviewed in the same office that Judge Thurman mentioned, the one that's stacked with papers up to the line of fall from his desk in all directions. When Jim and I started, this was a small community, all contained basically on the second floor of the courthouse. There were two active judges, a bankruptcy judge, and interestingly, for about two and a half months until Judge Mabee was appointed, Judge Jenkins did double duty as the bankruptcy judge and a district court judge. We worked in two courtrooms at once. But the clerk's office for both bankruptcy and the district court, the part-time magistrate, the judges were all on that same floor. There were no computers. All dockets, all filings were in paper. All calendars were on paper. And my first job for the first week in Levi's was to take and the post office was still in full function on the main floor, was to take a post office gurney and trade Judge Anderson's library for Judge Ritter's library because Judge Anderson wanted to retain his bookmarks, as best I could tell. We reviewed case files, and our job was different than I think subsequent law clerks because we spend an immense amount of time in those early months going through files that the clerk's office told us was the group of Judge Ritter's files. Turns out that they didn't have a complete list, and we had to keep mining deeper. When we'd do one-page handwritten bench briefs, there were no mag card typewriters even, no computers, and the judge spent weeks on 15-minute intervals doing status conference trying to jumpstart this docket. Just two points. We had one case that was pending that had been remanded by the circuit in 1971. Another one that had been remanded from the circuit in 73. One of them, Judge Jenkins refused to hear. The other one, the attorneys were patiently trying to outlive Judge Ritter. It was an interesting experience.
Thank you, Ted. Judge Mchugh, tell us a little bit about what your expectations were when you started your clerkship and what it meant to you.
Well, I don't think I had any real expectations because I was, I really didn't know any lawyers. I mean, I'd finished law school and done some summer clerkships, but I knew very little about really what happens. They don't tell you that in law school. And so I felt very fortunate to have gotten a clerkship. Is it on? And so I didn't know what to expect. I was just excited to be there, and I was very intimidated by Judge Jenkins. And I think that and at first I was very timid to ask him about things and stuff, but pretty soon I figured out that he was really a great big teddy bear. And so I could ask him any dumb question, and he would take the time to explain it to me. And looking back at it, when I got into private practice, I realized that it was an amazing experience because in 1 year, and I shouldn't say this because it will encourage people to go do trial court clerkships instead of appellate court clerkships, but the first time I had to do jury selection, I had seen it done a bunch of times. The first time I had to cross-examine a witness or do opening or closing, I mean, you saw lots of styles of people doing it. You had an opportunity to discuss with the decision maker how the way the evidence was presented impacted the decision maker. And the judge always had a very open door policy, and we could come in and ask questions, and he was always willing to talk to us about it. And so it's amazing how much really you learn watching someone who's so committed to understanding the cases and the idea of taking time to understand it, to know what you're doing in the video. That was certainly the case, that the judge would sit and think about things and then discuss them with you. And I know that when the first time I actually put on a robe to go sit on the Utah Court of Appeals, I remember thinking that every single time the judge would come and he'd put on his robe as he was walking by where we sat and go out a different door. He would go in a door that opened onto the bench, and we'd get up and go around and sit in our clerk chair. And every single time he'd walk in and he'd say, "Okay, kid, let's see if we can do some good." And that really was the attitude. Let's go see if we can straighten this out. Let's go see if we can do some good. Let's see if we can help these people resolve this conflict. And I really do think about that every time I robe up, as we refer to it. So thank you for that.
Paul, tell us a little bit about the culture of Judge Jenkins' chambers when you were there. What was it like to work with Mary Lynch and Russell Curl, and the judge?
Well, all three of them were great. It was just a great atmosphere. The judge isn't a micromanager of his law clerks or his staff. He just expects us to do what needs to be done. And so we had a lot of freedom, but he was always available to talk to, would talk about cases or whatever. Mary was great too. My favorite Mary Lynch story occurred in the mid-1980s when, during the reign of Ted Cannon in the Salt Lake County Attorney's Office, there were allegations of sexual harassment going on. And one day the judge's good friend, Jed Shields, called up to see if he could invite the judge to lunch. And Mary answered the phone, and he says, "Mary, this is Jed. I'm calling to see if the judge has anything on today." Mary says, "Just a minute, I'll go see." And she got up from her desk, and this was in the ceremonial courtroom, and it was quite a hike from her desk to the judge's desk. She walks all the way to the judge's desk, turns around, walks all the way back, picks up the phone and says, "Yes, His Honor is fully clothed today." And Jed didn't miss a beat, and he says, "Well, I must not have the county attorney's office then."
Okay, John, tell us about your experience of culture in Judge Jenkins' courtroom with Mary Lynch and Russell.
Well, I first have to say that Mary had left working for the judge by the time I got there, and Kathleen Smith was there, and I understand Kathleen had come over from the governor's office, and she was terrific working for, and she's still with the judge today. So I think she's as much a part of this as anyone, and I give a great shout out to Kathleen, who for some unknown reason is ageless. It's the one secret I've been trying to pry from her for 23 years and haven't been able to get it. The judge also seems to have taken on this ageless component. He doesn't seem to get any older. But I was lucky enough, as Judge Mchugh and Paul, to have the chance to work with Russell Curl as the judge's clerk. He was my co-clerk. And for those who didn't know Russell, he was a polymath. He knew a lot about a lot. There wasn't anything you could get by him. I remember one day something came up in chambers, and we needed to know the boiling point or melting point of aluminum. And without missing a beat, Russell gave it off. And I quickly ran to the library to make sure he was right, and of course he was. But he was a wonderful presence around there. And not only did he know a lot about a lot, but he could do a lot. He was a wonderful writer. He assisted on many of the judge's best opinions. I think he assisted the judge with some of his speeches. He was a mentor to all the interns and clerks who came through. He was a friend and a trusted advisor and counselor to so very many people. And although this is a day to celebrate Judge Jenkins, I'm not so sure that you get to 50 years without having Russell there for a good portion of those. But I want to talk a little bit about my experience coming to join the chambers. I came from New York. I had never been in Salt Lake before when I came out that fateful Friday to meet with Judge Jenkins. And like Judge Mchugh, I was surprised. I got this big bear of a man that I had to meet. I'm only 5'5". The judge might be 6'6". I was petrified. And then Russell walked in. And Russell is almost as tall. And they were tremendously interesting and frightening people when you first meet them. But he became a very warm and comforting friend, the judge, right from the first moment. He cared about my family. He cared about my future as a lawyer. He told me I could work with him for a few months, and in his own way, we'll see how it goes. 6 months passed, and he said, well, it's still working. We'll see how it goes a little while longer. And that went for a while, and it was a great experience. And they were, Ken's here, the great documentarian from KUED. I had like 2 KUED documentarians in chambers. Russell and the judge are fully steeped in everything Utah. They know everything about the traditions, the institutions, the people. I could ask the most lame question, and they would answer it. They even filled me in why I couldn't go shopping on Sunday. It was great.
Let's talk about some cases. Judge Mchugh, you first. Are there cases that you believe reflect or typify Judge Jenkins' approach to as a jurist?
Well, the main one that I would mention was talked about in the documentary when that case was tried right before I came to clerk for the judge, but one of the earliest memories I have is the oral arguments, the closing arguments, were after I came to clerk. They were not immediately after the end of trial. And so the very first closing argument I ever saw was in that case.
In the Allen case?
In the Allen case. And then the entire year that I was clerking for the judge and Russell were very much involved in working on drafting the opinion in that case. And the judge would be walking around all the time with a lot of science books and physics books. And the other thing I have a strong memory about that case is Mary Lynch, who didn't have a computer and had to type all of the mathematical equations. You ought to go, if you ever want to read a great opinion, I suggest you go pull the Allen case and the site. And I apologize for that bunch in Denver. Which is what the judge always referred to him as, was that bunch in Denver. But it's 588 F Sup 247. It was issued in 1984 because of how long it took to actually write it. And I can't tell you about the case any better than the judge told the reader about the case. And so if you'll indulge me, I'm going to read you the introduction to the Allen case because it is classic Bruce Jenkins. In a sense, this case began in the mind of a thoughtful resident of Greece named Democritus some 2,500 years ago in response to a question put 2 centuries earlier by a compatriot, Thales, concerning fundamental nature of matter. Democritus suggested the idea of atoms. This case is concerned with atoms, with government, with people, with legal relationships, and with social values. This case is concerned with what reasonable men in positions of decision-making in the United States government between 1951 and 1963 knew or should have known about the fundamental nature of matter. It is concerned with duty, if any, that the United States government had to tell its people, particularly those in proximity to the experiment site, what it knew or should have known about the dangers to them from the government's experiments with nuclear fission conducted above ground in the brushlands of Nevada during those critical years. This case is concerned with the perception and the apprehension of its political leaders of international dangers threatening the United States from 1951 to 1963. It is concerned with high-level determinations as to what to do about them and whether such determinations legally excuse the United States from being answerable to a comparatively few members of its population for injuries allegedly resulting from open-air nuclear experiments conducted in response to such perceived dangers. It is concerned with the method and quantum of proof of the cause and fact of claimed biological injuries. It is concerned with the passage of time, the attendant diminishment of memory, and availability of contemporary information about open-air testing and the application of a statute of repose. It goes on a little longer, but I think you get the tenor. This is a thoughtful man who, from my experience, never lost his love of learning. And I think he brings that to the bench every single day.
Thank you. Ted, you want to talk about some cases?
I would, just a couple. The Allen case we've talked about a lot, but it was filed while during my clerkship, though the trial was later. One of my favorite Judge Jenkins quotes occurred at an Inn of Court meeting in the Riverside Country Club. right after the opinion was issued. Each of the judges there present was asked to comment on a significant case. We had Judge Bullock talk about Gary Gilmore and some things like that. Judge Jenkins alluded to the Allen case, and he recited the statistics we saw in the film, how many witnesses, how many plaintiffs, how many weeks of testimony, thousands of pages of transcript, how many exhibits. And he turned to Monroe Mchugh, who was present in the room, and he says, "And Monroe, I don't care if you affirm me or if you reverse me, but for God's sake, don't remand." I remember a couple of electric arguments, one of them involving the affiliated Utes cases, where a lawyer as exercised as any I've seen in 35 years grasped the podium where I thought he was going to crack it, and pointing to the other side, "They've said in their briefs that I intentionally misled the court. He's saying I lied and he should be disciplined." The lawyer on the other side got up and said, "I meant what I said, and if I'm wrong, I should be disciplined, and if I'm right, he should be." Bob Campbell was sitting in the back of the courtroom, was then, I think, chair of the State Bar Disciplinary Committee, and he referred them both for review by the bar. One more. I remember a case. It's gelled, and I'm not sure my memory ever was as good as it used to be, but some of these things I remember far better than arguments I listened to last week. There was a tax protester, Jim will remember this very well, represented by a guy who quoted scripture at length in his memoranda. He did a decent job in the trial, but his client was convicted. We get time to sentence, and he comes off the wall. His pleadings replete with religious arguments that this was the time to revisit the gold standard cases, that there was no money unless it was gold 9/10 pure. And he referred to, and here the wheels came off in the courtroom. He bore his testimony. He kept referring to Brother Jenkins, to the prosecutor, Brother Wheeler, who was doing his best to look at his best imitation of Walnut, trying to disappear into the side. And I was impressed with Judge Jenkins' dignity, with his ability to let somebody make a record in a very insulting and inappropriate context, and then proceed to do his job. We could talk about more. The Hi-Fi Shop habeas corpus appeals, librarian Gene Layton's in Davis County are disciplined for stocking the wrong sort of books. But these were memorable times. I think we were maybe blessed, Jim and I, because there were only two shows in town at that time. It was Judge Anderson's and ours, and we had a first row seat to some very interesting, very entertaining times.
Paul?
I'm going to tell another Judge Jenkins story. I remember we were in court, and the attorneys were very unhappy with the ruling of the judges, and they kept popping out of their chair and arguing with him. And we walked back in, and the judge says, "You know, kid, judges aren't as smart as they think they are." He says, "But they're not nearly as stupid as the lawyers think either."
Paul?
Following up on Ted's tax protester story, one of my most memorable experiences in the courtroom was another tax protester case. It was a criminal case, and it was set for a hearing on pending motions and to fix a trial date. And at some point in the hearing, the guy was representing himself. He had appointed counsel, but he was representing himself, and he was up at the lectern. And at one point in the hearing, he says, and the judge's longtime court reporter, Ned Greening, transcribed this for us. He said, in a loud voice that I can't duplicate, he says, "Your Honor, I am bound by the laws of God to state to you that you are in violation of your oath, that you are a criminal under the laws of this United States of America, the crime of treason. You have been and are a traitor of the United States of America. I command you in the name of Jesus Christ that the angels speedily take your spirit to the spirit prison and there retain you until the resurrection of the unjust. In the name of Jesus Christ, amen." And everyone in the courtroom just sat there stunned. Everyone, that is, except Judge Jenkins. And the next line in the transcript is, "The court. Okay, now let's fix a date. But my first exposure to Judge Jenkins also was the Allen case, even though I wasn't clerking then. It was my first semester in law school, and we had, our civil procedure class, we had the assignment to go down and sit in on a court hearing or trial. And so a few of us got together, and we heard that there was a trial going on down at the federal court, so we went down one afternoon and sat in on some of the Allen trial. And at one of the breaks, the gentleman sitting on the row in front of us turned around and introduced himself. He was Tom Wicker from the New York Times, who was covering the trial. And he said, he asked us, what we were doing there, and we talked to him for a little bit. He says, if you want a legal education, watch Judge Jenkins. Excuse me. He says he has total control of his courtroom. He doesn't let the attorneys get away with anything. He keeps them on point. He knows the issues. He knows the evidence. If you really want an education, watch Judge Jenkins. And then a year or two later, the judge came and spoke to the law school, and I decided at that point that I wanted to clerk for him. And I did something that I've probably never done before or since. I had an offer from another judge for a clerkship, but I really wanted to clerk for the judge. And so I called him up and said, I've got this other offer, but I really want to clerk for you. I'd like to know if you've made a decision yet. And I ended up getting the job, but my wife has given me a bad time about that ever since, because she says I chased him a lot harder than I ever chased her.
John, cases that you remember.
I remember them all, but I remember mostly a field trip we took. The judge was one of the few judges who didn't feel constrained by the physical limitations of the courtroom. So here it was, I'm new to Utah, 1997. He decides in one of the famous RS 2477 cases, this one involving the Burr Trail, something I'd never heard about. I heard about Aaron Burr back in New York, and I'd been to visit his grave, but this is different. He decides that there's a dispute. I call this case the over-enthusiastic Bulldozer case. Some folks down in Garfield County decided they wanted to widen the entranceway to Capitol Reef Park, and they were negotiating with the National Park Service on who had the right to do what in terms of dealing with the road. And in a matter, and I guess they were overly exuberant, they brought out the bulldozer one February day and just widened an 18-foot dirt path into a 30-foot road with culverts on either side. Well, the United States brought a trespass action, and they were infuriated. But the judge wanted to see what the fuss was all about. They brought up pictures and all that good stuff. But he says, let's go down and see what it's all about. So he arranged with the marshals, and I think we had 10 or 12 big giant Suburbans that lined up outside the courthouse on 4th South. Law clerks, me, Russell, the judge, court reporters, courtroom deputies. Every marshal in the office, I think, went because it was going to be a fun field trip. TV people followed along, and all the parties, people from Washington, all over, off we go down and visit the path. The judge holds a hearing first out on the trail. Itself unique. Then we go back, and he holds court in the Boulder Mountain Inn and has dinner in a place called the Hell's Backbone Cafe. I think he was trying to give it a hint. But ultimately, that was the most memorable experience I had. It was just a wonderful time and a unique experience, a unique Utah experience.
John, let me stick with you for 1 second, and then I'm going to ask the same question to the other panelists. On Fox News, we learned that all judges can be categorized as either activist or strict constructionist. So where does John, in your view, where does Judge Jenkins fit in those categories, or does he defy those categories, or what?
Yeah, the judge has written about this, and so I don't want to just get him wrong, but I'll give you my view. And this is an overarching view of the judge. Words have meaning. He's concerned always about what the words mean. But what does activist mean? What do you mean when you say a judge is an activist judge? My personal experience, and experience of many others, is that someone gets labeled an activist judge when they don't like the decision that's come down. Justice Kennedy's Supreme Court has said the same thing. He said an activist court is a court who issues a decision you don't like. There are many examples in the judge's career, I think, that indicate that he's not an activist judge. He's a considerate judge, a learned judge. Using one of the definitions of activist judges that's around today is it's a judge who makes law or legislates from the bench. The judge is an old legislator. He said so himself in many opinions. But he never would do that. In a case I think you were involved with, Alan, the HBO cases. Do you remember those? Mm-hmm. For those that don't know, cable TV was sort of new back in 1982, and HBO was new to Utah, and the state legislature enacted an act that made it a Class B misdemeanor to show indecent material over the cable wires. And they defined indecent to be anything that had nudity. Well, unfortunately for the Attorney General in the state, the Supreme Court had already ruled in a case that sort of limitation wasn't lawful. It didn't pass muster. At the time, the Attorney General gets to the case in front of Judge Jenkins and says, well, we know it might not pass muster, but you can rewrite this. You can leave some words out or put some words in to make it work. And he wouldn't have any of it. He wouldn't listen at all. There's some great language in that case that I encourage everyone to look at. It's not his job. It's not the task of a judge to do that. He's there to tell everybody what the law is, but not to make the law. And he's held up his end of the bargain all throughout. So he's not activist, because I really don't know what that means. He's not conservative. I don't know what that means. And I don't know what neither means either. Does that mean you're a little of both, none, whatever?
Judge Mchugh, activist or strict constructionist or what?
Or what? I guess I remember being asked, I was sitting in a room with people from the White House and the Department of Justice, and they were asking me, are you a strict constructionist? Are you an originalist? Are you original intentist? Or are you a living documentist? And I looked at them all and I said, well, if I have to be an ist, I choose jurist. I guess that's how I would describe Judge Jenkins. I don't think these labels or boxes work very well. I think he rolls up his sleeves. I think he learns about the material, does the work, and tries to figure it out and put things in order.
That leads to sort of the same question. Ted, what in your view, what values have motivated the judge to do what he does as a judge?
I'll respond to that and expand just a bit. I think fairness. I think he has an eclectic curiosity. As a voracious reader that was mentioned, the time I was there, I think his wife was complaining that he had over 4,000 volumes in his personal library, and that's many years ago, 10 now. His curiosity carried over to his jurisprudence. It was never enough to tell Judge Jenkins what you wanted the court to do. You needed to provide a context. You needed, as he would describe in his own speeches, to tell him the story. You needed to explain why, how it would affect others, because he wanted to fully understand the intended and unintended consequences of his decisions. He wanted to make sure his ruling was just as well as correct. Activist, inactivist, I never knew him to be an ideologue, but if he thought somebody had been ill-treated by society, by the government, some would consider him active in that case. I saw some lawyers chafe, tell him he didn't have the authority to do what he thought was right. I realized very early, as did they, that that was a dangerous thing to tell an Article III judge.
Paul, same question.
I think, well, what the judge said himself in the video about judging as a human activity, he's always said that he's always been amused by the term activist judge, because he says we don't go out and drum up cases, we just take whatever comes to us and we have to decide. That's our job. In getting ready for this, I reread some of his old opinions. There were two cases when I was clerking for him the first time where the district court said en banc. One was a bankruptcy appeal, the independent clearinghouse cases, and one was a U.S. versus Swap, where the court was considering the constitutionality of the relatively new sentencing guidelines. And in both of those cases, at the end of the opinion, and Judge Jenkins authored both opinions for the court, and at the end of both opinions, the court basically says, this is the result that we reach. This may not be good policy, but we're required to apply the law. This is the law. These are the facts. This is the result. In the sentencing guideline case, they declared the sentencing guidelines unconstitutional, but conceded that Congress could pass a statute again and correct the constitutional deficiencies. But then the court ended with, we don't think that would be good policy, and went on to explain how you can't really take the human element out of judging. That you can't reduce sentencing to a formula. You have to know the person that you're sentencing, and so like Judge Mchugh said, he's neither activist nor strict constructionist. He's just a judge. That's what he does.
You know, for the benefit of all the lawyers in the room who have appeared in front of Judge Jenkins, I need to ask the panel one question. Talk, if you would, let's start with Judge Mchugh. Question on Judge Jenkins's civil pre-trial procedure. For those of you who have not been through the exquisite pleasure of one of Judge Jenkins's pre-trial hearings, why don't you, Judge Mchugh, explain the process and then evaluate it?
I guess if for those of you that haven't been through it, essentially these can be very long pre-trials. They can go more than a day, and you are expected to, and I mean, it seems reasonable, as you get close to trial, you're expected to know what your claims are. You're expected to know what the evidence, what the elements are of each of those claims, and what evidence you have discovered that you intend to put on to prove each of the elements of the claims that you are bringing. And if you are have counterclaims, you're going to be put through the same test, and the same with any affirmative defenses. And that sounds pretty simple, because I mean that's essentially what it is. Obviously you can correct me, but it is surprising how many times when you're really quite close to trial that the attorneys don't really have a good sense of, sometimes they don't even remember what all is in their third or fourth amended complaint, and so they can be like taking an oral examination for your doctorate, I think. And sometimes they can be pretty painful. But in fairness, when I saw them happening in Judge Jenkins' courtroom, I didn't know that pretrials were ever done any other way. So the first time I went to a pretrial with a different judge, boy, was I surprised. So I guess critiquing it, I think I'll let someone else do that. I have a couple of my former law partners that might be willing to do that, because I certainly heard them whine about it often enough.
Ted, you want to talk about it?
The technique developed largely after I was there. We didn't have time sorting through this old docket to get into civil cases until about halfway through my clerkship. We were spending time doing the seminal jury instructions and working through processes that became rote, I'm sure, for others. But I've been a victim of his pretrial process a couple of times. And I think it's been highly effective for him. I'm not sure that many judges are confident enough, are active enough in their intellect, in their exchange, to engage lawyers spontaneously about those aspects of a case. Perhaps because of that, because of the press of time, they stay away from it. In one particular case that where I was lead counsel that went on for 7 years in front of the judge.
Just the pretrial?
No. Very nice. The case went on for a long time. Cost me I stayed back from seeing the judge socially during that time period. It was very appropriate, but in that case, it was very effective in limiting issues that were developed in inches of paper down to the 3 points that he had the opposing counsel, plaintiff's counsel, write manually on a sheet of paper on an easel. He worked with him until he distilled the case down. So that's what you want me to decide. Is that everything you want me to decide? Okay, then list the next point. And once he said, well, if those are the 3 issues that you want me to decide, fine, that will be our order. And we proceeded from then. And it was a much streamlined case, much more effectively presented in that case because of that discipline.
Of course, the fun part in one of these pretrial conferences is that you've had a motion for summary judgment that may or may not have been pending for a while, or a motion to dismiss, and what you find out during the course of the pretrial is that Judge Jenkins is going to rule on it at that time based upon what you tell him. And sometimes he rules on it and he doesn't tell you until the morning of the 3rd day or the 4th day. This happened in the Bonneville Pacific case, where we got there and I said, Judge, can we talk about my counterclaim? He said, oh, that's gone. Oh. And it was gone. John, Paul, anything you want to add about the pretrial conferences?
Well, I have the luxury of talking about them because I've never had to appear before Judge Jenkins. But I think there's a value in it, as Judge Mchugh said, and I think that the judge views it as part of what he sees the duties and responsibilities of an attorney before the court, and that's to be an educator. And he's there to be educated. And he expects them to, as Ted said, distill down the important facts, distill down the problem that needs to be solved and resolved, to clarify the issues for the fact finder, and to get that all done in a way that makes things that were confusing clear and keeps the important issues and discards the stuff that's irrelevant. And I think that's where it gets really hard. I know in practice, we live with our cases for many years and we have all these great theories and facts and stories we want to tell when we get to trial. But, we've built up some interest in them that really isn't necessary to solving the problem that a fact finder has to resolve. And his pretrial conferences do that. They're great distilling efforts. And as a clerk, it was great watching people squirm. I mean, it was wonderful. He'd come in, and the big man on the bench, and he says, oh, tell me what the case is about. Tell me. And you'd be petrified. And many of you have seen the judge in action, and it goes like this sometimes up on the bench. And I swear some of the lawyers thought he was sleeping up there and would just love to throw something at him. But he was taking it all in. It was the way he assimilated the education that he was expecting to receive from counsel. I think it's a great process. Wish more judges did.
We have just a few more minutes before we need to break up and go outside, and we can hear from Judge Jenkins. So I'd like the panel members maybe to just reflect for a few moments, each of you, on what your clerkship meant to you professionally. Judge Mchugh.
It was a fabulous way to start my career because it instilled in me the importance of treating everyone with respect and a deep-seated belief in the system itself, in the process itself. And I think that, and I guess I look at it not only in my private practice career, but also on the bench, Judge Jenkins really didn't treat it as a job. He treated it as a sacred trust. And that is something that I would love to emulate. So.
We had a close time. Again, it was a small group. It was informal. Jim and I had the privilege of starting from scratch on everything from new furniture to jury instructions. For me, it was the best possible thing I could have done between law school and practice. We didn't have a lot of practical experiences in the law school. They do a much better job with clinical work then. But I come from a background with no legal experience in it. A few clinical opportunities, and I learned there, I think, how the law is supposed to work. I learned from Judge Jenkins the value of a broad education, of the use and the value of words, of telling a story, and of civility. I learned maybe the most concrete lesson, the one of best applicability to my practice, was an exchange I had with a lawyer who was submitted an order, told us, called and said, don't sign that. Tell the judge not to sign it. We've settled the case. A week later, they submit the identical order. And judge says, call him, ask him what the difference is. Wasn't it settled? And I called him and he says, I didn't say it was settled. I never would have settled. You don't understand. Lawyers across the nation have reviewed that order, and you failed to perceive the difference. This was a question I was asked to call by the judge. I went in dumbfounded that somebody would have the poor judgment to tell the clerk something that they didn't expect the judge to hear. He looked at me and he says, we all have our lists of lawyers that you can trust, and you've just started yours. The value of reputation is something that strikes and that has stayed with me from that comment. Whatever level of success I've achieved in the practice of law, I trace back directly to the 15 months I spent at his feet.
Well,
I never wanted to leave Judge Jenkins, and had it not been that Russell had more seniority than me, I might still be there. But I'll always remember something that the judge said. He spoke when I was sworn in as a new attorney. He spoke to us new bar admittees, and I will always remember something he said in that talk. He said, "You leave your moral fingerprints on everything that you touch." But he also says a lawyer has a professional obligation to think, and I think those two things, thinking and having integrity, and are the two things that have stayed with me the most.
John?
So many things have changed my life when I came out to work for the judge. But there's one Judge Jenkins aphorism that sticks with me probably more than any. And he's used it in opinions, and he uses it in chambers, and he uses it in the courtrooms. The long way is the short way. And that's stuck with me forever. He befriended me when I came out. That changed my life. He let me participate in a forum of great intellectual challenge. For those of you out there who are thinking about clerking, do it. It's the greatest job in the world. I wrote down here just a few of the cases I dealt with in 1 year with the judge. We dealt with the design of golf clubs, a patent. We dealt with a company trying to design a golf course on land it didn't yet own, which was an interesting case. We dealt with the maintenance of oil pipelines in the backyards of folks in Davis County, and they didn't even know they were there. We dealt with base jumpers many times. The 10th Circuit dealt with them too, Judge Mchugh, and the judge didn't have much nice to say about them on that case either. The judge dealt with the limitations on speech and conduct of an exemplary school teacher down in Utah County that was of great import at the time, on issues that are still of great import today in Utah. We dealt with the rights of gay and lesbian students in East and West High School to meet. We dealt with those disputes in Canyon Country about paths and roads and all those hotly contested issues that were more about power and personality than protection and preservation. We had kidnappings, drug smugglers, drug dealers, murderers, bombings, frauds and fraudsters, self-proclaimed sovereigns, and actual sovereigns. It was the best job in the world.
Let me, on behalf of all of us, thank our panel members. That was terrific. And now it is Judge Jenkins' turn to respond to all of this. Judge Jenkins, would you say a few words and let us thank you for 50 years of service?
Well, thanks to all who have participated, not only in the preparation, but in the actual application of this event this evening. 50 years is like an instant. Now, there are two really important things other than saying thank you to all of you who've been part of my life. Obviously, my good-looking family members who are here, they're all good-looking. And they're all smart. I want to thank the bar. Thank the Historical Society. I used to call it the Hysterical Society, but the Historical Society. And I want to emphasize that there may well be continuing legal education credit. That's a bonus that you didn't think you were going to get. At least I've been told that it's forthcoming. And secondly, I want to advertise the fact that we've got free food. Free food, which is what I usually advertise when we've had historical events such as this. I want to thank my former clerks here and many in the audience. What a joy it's been to deal with energetic and thoughtful and able people in trying to do a decent job in a public performance. I've enjoyed each day. Some days I've enjoyed more than others, but I've enjoyed each day. And each day is important, and as I mature and time accelerates, which it does, I remember the words of a Buddhist abbot that are favorite words of mine. He said, in our journey towards enlightenment, each step along the way, each eternal now is as important as our destination. How you use your time and your energy, I think, is a challenge for all of us. But particularly in the legal profession, I think the manner in which you use your time and energy is particularly important. And one of my favorite animosities is the fact that we end up counting each 6 minutes as we keep our timesheets so that we can bill for each 6 minutes. And I sometimes wonder whether we have lost the fact that we ought to be perhaps graded not on time but on performance, on what we do with the eternal now in what we have. I'm grateful for all of you to come tonight. I'm grateful for the Historical Society's determination to provide this opportunity, not just to me, but to you as well. Thank you very much for coming, and please take advantage of the food that's readily available in the hall. Thank you so much, everyone.